I'm really looking forward to today's webinar. I'd just like to begin by acknowledging the traditional owners of the land on which we meet today, which for us is the land of the Kulin Nation, and pay my respects to their elders past and present. I extend that respect to all Aboriginal and Torres Strait Islander peoples here today. Thanks, Margaret.
Thank you, Remy. I think it's important to recognise that the oral traditions of Aboriginal people, the First Nations people, is really relevant to the collective traditions as well in union history. You won't find out there a manual that sets out this is how you win a particular type of new condition of employment that's an improvement. You'll find that that's something that is passed on really through union structures, through delegates and members with their stories about how things were won. And that is part of the reason for why we're having today's session, which is different to what we might normally do, which is simply provide, well, here are the changes, this is what you need to do, because I think we are starting to lose some of the history that lies behind the Professional Employees Award. And in losing that history, we're losing the understanding of some of the quite extraordinary wins, but also what to do when you have setbacks, and also the kind of the huge collective efforts that go into winning these sorts of changes. So before we get going, I just wanted to check, and my screen is just showing, it's not showing all the participants. So what I might do, Remy, is if you could have a look once this happens. I'd like to ask, first of all, how many people attending today are members of Professionals Australia? If you could raise your hand, which you can do at the lower end of the, that's it. A lot of you have found it. It's at the bottom of the screen, raise hand. So that's good. There's quite a number of members here. Some of what we'll be talking about during the course of this presentation, you will be able to take some credit for because of your participation in surveys. We'll come to that a bit later. For those of you that aren't members, look, we really appreciate you attending. One of the things that is really critical around modern awards is that it wasn't that long ago where modern awards played the part that enterprise agreements play today. And just before I get into all of that, can we now ask, could you lower your hands? Everyone lower your hands, thank you. And there's one more question I'd like to ask before we get right into this, just to help situate it all. So we've got 4 people with their hands still up, but that's okay. Could everyone raise their hands who are currently covered by an enterprise agreement? So I'm seeing about 28 out of 68 are currently covered by an enterprise agreement. So just to put this into a bit of perspective, prior to the 1990s and in the federal system, there was largely industrial awards that regulated employment. And that's in many respects the origins of the Modern Professional Employees Award. The Modern Professional Employees Award is in fact an amalgamation of several awards that were brought together. There's the Engineers Award, the IT Award, and also Quality Assurance and Auditor type awards. Those of you with your hands up, you can take them down now. Thanks very much. And in the way that today enterprise agreements were the primary way that unions tend to engage with members. There's some notable exceptions, and we'll talk about that a bit. Awards used to be that as well. With awards, so let's go back to the first iteration of the Professional Employees Award. It all started really back in 1961. At that time, there was a case that was brought by the Association of Professional Engineers. And I'm talking about the engineers because they were the first professionals outside of teachers and nurses to obtain industrial recognition under the system at that time. And that's important because to this day, the modern award system only covers certain professional groups, even though professional employees have vastly expanded over the last 20, 30 years. And the way that the legislation currently is worded is that only those professional or managerial employees who were traditionally covered by awards can continue to be covered by awards under the miscellaneous award, that is. So to get other groups into the system requires quite a significant process of bringing an award application, making the case. It's a public process, so it's subject to people and organisations objecting to that. And in fact, Professionals Australia is currently involved in that process with translators and interpreters. And it's already proving to be a lengthy process under today's legislation. The Labor government has indicated that it is thinking about making further changes to the award system to expand and make it a little bit easier to bring improvements through. But that isn't even part of the legislation that we're aware of in the current bill that's before Parliament. So the awards system has become a system that applies to a limited group of employees. And with the professional engineers case, what that did was to establish for the first time that professional employees outside nurses and teachers were an occupation and therefore could be the subject of an award in their own right. And following that, the scientists and other professional groups, even the IT groups, that is how they also came to be able to establish an award under the system as it was. The Professional Employees Award today, and we'll talk a bit more about coverage shortly, but I just want to give a kind of broad picture. It plays still a very important role. For those who are on enterprise agreements, you'd be aware that it sets the threshold, the floor, against which your enterprise agreement is assessed as to whether you were better off overall being on the agreement than you would be under the award. Contracts of employment of those who are covered by the Professional Employees Award will also give way in their terms and conditions to the extent that they are inconsistent with the award. So a contract of employment that didn't provide, for example, the minimum rate of pay that is provided under the award for the work that is covered under that award would be invalid and unenforceable as a contract. And in fact, as an employee, you'd have the right to seek an underpayment claim. The Professional Employees Award today also does reflect the fact that it applies to professional employees. And that's reflected in the period of notice that you give or the employer gives when the employment relationship is coming to an end. And there's a separate video you might like to have a look at about the redundancy arrangements for professional employees award that does go into a little bit about what you need to do when you resign, other ways of being terminated, that kind of thing. So we won't go into that today. But what it does provide is that, unlike other awards, it provides for a minimum of a month's pay when there is notice to be given. Obviously, as an employee, you give notice. You don't have to pay the employer. The employer, though, if it terminates your employment, will need to pay you for that month's pay. Now, that's higher than what you will generally find under other awards, and that reflects the professional nature of the employment that is covered under that award. The thing about awards is that they have been dramatically stripped back. That happened largely during the Howard government years. And as a result, they are very much bare bones documents that set out terms and conditions. They work with, and I'm assuming most of you are aware of what are called the National Employment Standards. The National Employment Standards cover issues such as annual leave, parental leave, and so on. There's quite a list of them. And that works with awards. So those who have the benefit of an award also have the National Employment Standards as well underpinning your employment. And the awards tend to reflect what's in those National Employment Standards. So I'm just going into this to just provide a little bit of background here to all of this. So in the 21st century, we've seen awards being stripped back. And we've also seen in professional employment, hours of work dramatically increasing in many cases. And what our union surveys were telling us was that those employed under the Professional Employees Award, and engineers and IT people generally, as well as scientists, were finding that your hours of work were increasing. So you'd be aware, I think most of you on here will be aware that Professionals Australia runs annual surveys. Those surveys are about remuneration. They have an immediate use soon after they've been analysed and put together of you being able to access those to get a sense of what might be a market rate of remuneration. But they also have played a very vital role in the professional employees case that was run in 2022, which led to this decision. And what that was telling us pre-pandemic, so we're talking about 2019, was that there was a significant number, around 8 to 10% of employees who, if you looked at all the hours of work that they undertook, they were not getting the equivalent of the hourly rate of pay for all of those hours of work under the award. And we'll shortly see just what the minimum rates of pay are, and you'll appreciate just what that was telling us. And that was the primary evidence that we used in our first attempt to try to get the hours of work provisions changed, because the clauses in the award were not enforceable when it came to working above the standard 38 hours per week. You'll all be aware that one of the national employment standards is that the full-time hours of work are 38 hours, but employers may request employees to work additional reasonable hours. And then what is reasonable and what may be unreasonable is subject to another provision of the legislation that takes into account a number of individual circumstances. Now, a couple of things about that. The first thing, the overtime provisions in the award simply left it up to the employer to decide how that would be reflected. So whether or not someone got additional pay whenever they worked overtime, whether there was an upfront annual salary that was meant to include the additional hours. But when it came to the case itself, the commission itself looked at the clause and said, well, really, the employer could give you a pizza and say that that's the payment for your overtime under this award, the way it's structured. Anything. There was no quantifiable amount that was payable. Now, the way that had been set up was intended to reflect that professionals as employees need to be able to exercise a level of judgment and discretion in how they will go about performing their work and what it requires. And therefore, it's the work that they produce that is relevant rather than so much the hours that they perform. They don't necessarily clock on at 9 and finish at 5, but they need to be able to exercise that judgment in the way that they undertook their work. Obviously, you can see how that came to be exploited, where it was seen as, well, there's no requirement on the employer to really pay anything of a quantifiable amount extra for the additional hours that were worked. The other thing about the way that the hours of work have been regulated in the current arrangements is that employers can request reasonable additional hours. And then the provision about, well, what is reasonable additional hours is that we've found as a union very difficult to tackle because it is individualised. It does require individual employees to say, I think what I'm being asked to do is unreasonable to their employer. And if their employer pushes back, for that employee to be prepared to take it further. So that part of the legislation is not really working as intended. It might in some workplaces where they are more inclined to take into account people's, family and other personal commitments. But with those that we're seeing through the Workplace Advice Service, it really doesn't provide a lot of assistance to individual employees that are being, let's put it bluntly, exploited. So one of the things that we were keen to tackle in the award itself was to make the award stronger around working hours. In the first effort, we put forward the survey material. We didn't actually put forward any witness evidence as such, but the Commission decided in 2018 that, yes, the safety net that the award was meant to provide was not working when it came to hours of work. They rejected, though, the proposal that was put forward at that time. And that proposal was based on, and this starts to draw on, for those of you, okay, let me explain. So there's 5 levels of classification under the Modern Employees Award. And it was just the first 2 levels that it was proposed to provide for specific overtime arrangements. The Commission was not satisfied that that was adequate, and so they really asked for further submissions. And then we made further submissions, but it all got caught up in the pandemic and it kind of fell away. It was revived again in 2022 by the Commission itself. I was relatively new to this job, to this role, and still coming to understand really what I was starting to learn about what we call the areas of our membership where the members do not have the benefits of an enterprise agreement. And when I say that, what I mean is that the members who do not have an enterprise agreement will find that it's very much an individual contract arrangement, and they're dependent on what might be in the award that actually provides some additional assistance. And what we were finding very much in the Workplace Advice Service, and I want to crunch some numbers on this actually, but we tend to find that there is a much higher proportion of individuals in those areas that do not have enterprise agreements that find themselves dealing with difficult situations in their workplace, who have individual grievances about how things are determined, about whether or not they should get a pay increase, whether or not something has been decided in a discriminatory way. The numbers are really much greater. And that tends to be the way that the union at the moment is mainly engaging with those employees in that area. There's a notable exception, and I'll talk about that a bit more because it relates to the evidence that we ran in the second attempt in 2022. But what that was telling me was that we were not really finding ways to look at how do we work together collectively for those who are under an award. And certainly the Secure Jobs Better Pay legislation that came in December has provisions that are intended to make it easier for members to be able to gain enterprise agreements or multi-enterprise agreements. But that still involves a lot of work, and it involves us reaching beyond what we currently reach when it comes to the areas that do not have enterprise agreements. What we know, back in the 60s, when that first case was won, engineers were recognised as employees who had an occupation and therefore were entitled to the benefits of the industrial relations system then. We were looking at a 60, 70% union membership. These days, we're looking at an 8%, roughly, membership in the private sector. This award, the Professional Employees Award, relates to the private sector. So to that extent, if we want to make the most of these changes, and that's part of the reason why I've broken this down to parts 1 and parts 2, and I think there may in fact be parts 3 and parts 4, but that's something that you and others will have a decision to make about that, is that we really need to be looking at how do we organise and make sure the changes that have come through are implemented and we get the benefits of them. And also there were things we didn't win, and how might we win those if we really want to do something about hours of work. So the case in 2022, interestingly enough, the numbers of those, so that number 8 to 10% that we were finding were not getting the equivalent of the minimum hourly rate under the award for all hours worked, had decreased. It had decreased both for the engineers and for the scientists. And we have a little bit of difficulty with our IT surveys from that time to really be able to identify the shift, but also there'd been a drop there as well. Sorry. So we were a bit concerned about what that might mean for the evidence that the Commission was now considering. And also we did look at, well, look, generally you need witness evidence. And again, this was a problem we had this time round because we don't really have the engagement with our membership in areas where there aren't enterprise agreement. It also means that we didn't necessarily have a number of people we could call on to provide evidence. The big exception was the Game Workers Union, who became part of Professionals Australia in the last couple of years, and have really, I think, challenged us to think differently about how we organise in areas where there may not be enterprise agreements, and it may be very difficult to gain enterprise agreements, but we still need to organise and we need to look at how we bring about improvements. The award is one of the vehicles for doing that, so that's partly why I'm talking here today. Because one of we were able to draw on the experience of one of our organisers who had worked in the game worker industry himself, to talk about how hours of work operated. And that was one of the key pieces of evidence that was used. We were also able to draw on the extraordinary experience of one of our staff, who is actually just retiring this week, who has worked for 43 years with the union. And she was able to talk about her knowledge of how professional engineers and professional scientists in all sorts of parts of industry had hours of work organised, and that went forward. In fact, as evidence in the case, it was interesting. The employer parties initially were supportive of the case to provide overtime rates of pay for levels 1 and level 2. But once we started talking about all levels obtaining additional payment for working additional hours, they became opponents to us. So in the most recent case, in 2022, we were up against both the Australian Industry Group, which you'll probably read about in the newspapers. They tend to oppose most of the legislative changes that are happening as well, and also the New South Wales Chamber of Commerce was also there opposing. And at the end, a firm in WA, one of the consulting engineer firms, also put in a submission opposing these changes. So you should have on the screen there what the minimum rates of pay are for the level 1 graduate. And what you see there is what the annual rate of pay is plus 25%. And I'll go to the next slide. So you can see there's also level 2, level 3, level 4, and level 5. Now, because this is an amalgamation of awards, where it talks about experienced professional, that's referring to scientists as well as engineers. Where it talks about professional senior, that is professional, level 3 professional, that will refer to professional engineer level, and so on. Now, level 5, that's highlighted in red because it only applies to the experienced medical research employees.
Sorry, Margaret, someone's just asked for clarification around the plus 25% under the classifications.
We'll come to that.
Yep.
That's okay, because that is really one of the major changes that have come through, why that's there. So that's just to give you an idea of minimums. Now, the other thing that we need to sort of understand, and look, I need to go back a bit here. Let me just check. Let's start to get to the tin tacks here of whether you would be affected by these changes. So there's a series of questions there. Are you a professional engineer, professional scientist, an IT professional, or a quality and assurance employee? If yes, possibly the PE award affects you. Are you employed in any of the following? Local government, the rail industry, the electrical power industry, or water industry? If you say yes to that, then this award probably does not apply to you, but there are awards in those other industries that probably will apply to you. So that, stay tuned about those. Does an enterprise agreement apply to your employment? So the changes that are made under the award will not directly flow through to those who are on enterprise agreements, because the enterprise agreement regulates your employment, but your current and future enterprise agreements need to at least reflect what is here. So, for example, let's say you are a graduate who works at TELUS. TELUS is one of the employers who does defence work, is one of the employers that has an enterprise agreement, and the professional engineers who work there, or professional scientists, IT people, would come under the Professional Employees Award. Now, if there is an enterprise agreement that provides a rate of pay in it as of first pay period on or after 17th of September coming up, that is less than what those minimum rates of pay were, TELUS is obliged to ensure that you are paid the minimum rate of pay. There's a specific provision in the Act that says that enterprise agreements need to reflect exactly what the minimum rate of pay is in the award. Now, usually that's not an issue because the minimum rates in awards are very much minimums. But as you've just all seen, there's a 25% factor that's come into it. Now, the other thing before we start moving a little bit more into coverage is what does your letter of engagement and or contract of employment say about award coverage? Now, quite often they say nothing. But if it does, that is worth looking at and considering. So I just wanted to go through that, as well as understanding a little bit more about, so who are those who are covered by this? And as I touched on, an employer like TELUS is covered, as are those in the professional engineering, professional scientific duties areas, those who are principally engaged in the IT industry, the quality auditing industry, or the telecommunications services industry. Now, Telstra people and Optus people, if there's anyone, this award does not apply to you, but we can come to that later. And also medical research institutes with employees performing professional medical research. Now, there's a lot there. Coverage is probably the most complicated part of the award to understand, and it goes back to that history, and it's important to understand that history. One of the reasons why the Commission brought this back on was because in unfair dismissals, they'd been finding this award very difficult to figure out whether or not it applied to someone's employment because of the way that its coverage clauses and classifications were worded, and the way that they apply a test, which is like, what's the principal purpose of your employment? And so they brought this matter on to try to make that part of the jurisdiction of the Fair Work Commission a bit easier. I don't know that they achieved it, but what they did do was change that if you are classified in any of those classifications, it's provided that you're not employed in a wholly or principally managerial position. So that doesn't mean that if you supervise others and you're at level 3 or level 4, that you won't be covered by the award. What does this wholly or principally managerial position will need to be determined, I think, through future cases. And again, it's one of those things where, as a union, we could play a role in how that will be interpreted. But a couple of things need to happen. Firstly, we need to have the resources to be monitoring what unfair dismissal cases that are involving employees potentially under this award to know whether or not the issue is even coming up. And that's a huge exercise in itself. And secondly, we need to be able to put forward some evidence that shows, well, look, this is what you would say is a supervisory role in this industry, and this is what you would say is a wholly managerial or principally managerial position in this industry. So we need evidence, and that's not something that I can make up or others in the team can make up. It's what we need to be able to ascertain from our members on all of that. Now, just ignore this for a moment. I promise you we're getting there. We're really getting to what the changes are now. But the other thing that was also a result of the coverage change is that when someone is now appointed to a position that is covered by the Professional Employees Award, the employer should notify you of what classification under that award you come under. Now, I would put money on that most employers will not do this unless we make this one of our organising focuses over the next 12 months, 2 years. It's also, as you can see, it's got some pretty important implications. First of all, you can only know if you're classified, if you're being paid correctly, if you've been classified correctly. Now, I haven't gone into what the classifications are in any detail. So there's descriptors for each of those level 1, level 2 through to level 5 classifications, which we will come to. But also in assigning this classification, the question will be, does that amount to a change to your contract? Because if it does, then at that workplace, you as an employee are no longer subject to, if there were any confidentiality provisions in your contract about maintaining pay secrecy, maintaining confidentiality about your remuneration. The recent legislation, the Secure Jobs Better Pay legislation, provides that once your contract changes or you enter a new contract, those pay secrecy provisions no longer apply, even if they were in your contract. So that's important too. And that's got another implication for organising in a workplace. It's relevant to whether or not whether you can bring an unfair dismissal claim. If you're covered by an award, it doesn't matter whether your pay is well above what the minimum award rates are. If you're covered by the award, you still are entitled to the access to the unfair dismissal provisions. And that's why what I was talking about before with the Commission looking at, we want to change this a little bit so that it's a bit clearer about who is covered by the award and who isn't. And then as the last point, which I now need to really get to start explaining to everybody, quite understandably, is, well, if you're not paid at least the minimum award rate plus 25%, it becomes very relevant to your entitlements to overtime, etc. So let me jump ahead now to, where are we? I think it's here. Okay. I'm going to run through now what the provisions were before the decision and what they will be, and with effect from 17 September. So the weekly hours of work, 38 hours, no change to that. There was no span of hours in which are considered ordinary hours of work. Now that in the old award. Now that's really significant, because generally the way overtime is calculated is to know, well, are you working outside the span of hours? So as you can see, there is a new span of hours, which is 6 a.m, 10 p.m, Monday to Saturday. Now that's still a very broad span of hours. Sundays and public holidays with that are outside of ordinary hours that you would expect overtime rates to apply or penalty rates to apply. But it does mean, and this is one of the things I probably should have mentioned earlier about the Professional Employees Award as it had been developed. It was recognised early on under this award that employees under it would be required to be contacted after hours and provide advice over the phone or remotely via computers and so on, because of the nature of your work, that you're consulted, your advice is sought, and so that remote work can be counted as overtime work. And that is an important achievement, because often even with our enterprise agreements, getting that recognised isn't that straightforward. Now, as I have explained, overtime at the discretion of the employer, that's changing too. Now, the employer's got a choice. This is the 25% factor. If they pay 25% above the minimum award rate of pay, then they do not need to pay additional overtime and other penalty arrangements. If they don't pay at least 25% above the minimum award rate, then they need to pay the minimum award hourly rate for all additional hours that are worked. Now, I'll keep going because there's some more changes that it's important that you across. So penalty payments, there were none specified. Now we've got 125% of the minimum hourly rate for working before 6 a.m. So that's the ordinary hours, the span of hours I'm talking about before, Monday to Saturday, or after 10 p.m. Monday to Saturday. Penalty payments for working Sundays, there were none. There's now 150% of the minimum hourly rate for each hour worked on Sundays. Penalty payments for working public holidays, there were none. It's now 150%. Now, there is one of the reasons it was difficult to actually enforce anything under the award is that it just permitted averaging of hours. So what I mean by that is that over a month period, your 4 times 38 hours could be averaged, so that 1 week you work 36, 1 week you work 40, and so on, so that overall it works out 38 hours. Plus, remember, additional reasonable hours. What the averaging hours under the award now is, which is actually a lot better than a lot of other awards, which often go up to 6-month periods that they can be averaged out, is 13 weeks. Now, that is something that makes it easier for us to enforce, but we can only enforce if we've got cases. And when I say enforce, I would like to think that we can get beyond enforcing individual claims at a company and basically address what is happening at a company level for those that are employed there. So if there is, in fact, a level of additional hours being worked and it's the 25% above the minimum award rates not being paid as the annual salary, that we're able to take that on and get somewhere with it, without necessarily needing to treat it as a underpayment case that we need to enforce through the courts, which, you know, as lawyers, that's exciting, but it's time-consuming and not a very cost-effective way of ensuring conditions of employment are being improved. Far better if you can persuade company by company that you are serious about enforcing rights and that our members get them much more quickly, and we can establish arrangements so that we know that things don't fall back 6 months later. There is an alternative provided on the award, and this is one of the standard provisions across the award system, and that is that it is possible for employees to agree to having time off in lieu. The important thing about that is, and I just want to highlight this, is that it is to be taken within 6 months. But as an employee, you have the right to request that it is paid, and that can then be paid, and it must then be paid the next pay period following the request, or at the end of 6 months, or on termination. So if for whatever reason you're leaving the employment and you've got time off in lieu you haven't taken, then this award provision gives you the right to have that paid out. This is all assuming that you come under you're not in that 25% plus bracket. Now, the thing I just wanted to point out about all of this is that those employers that do not provide the 25 plus bracket will need to start maintaining records. That is actually a requirement under the award itself. That also gives us an ability to go in and inspect those records and make sure they're being maintained properly. But the thing that I wanted to mention about all of that was that, let me just see here. Okay, so there's a couple of things I just wanted to mention here. So callbacks includes electronic devices or otherwise remotely. The award does not require the employer to authorise the employee to perform overtime. So the award itself does not say you working the additional hours must be authorised by the employer. And that's something that I think we will need to discuss more in the next session about, so how do we ensure that your hours are actually being calculated properly. Similarly, as an employee, you're required to keep a record of the overtime you work if you want to claim it, and a description of the work you perform, which must be provided to the employer. And again, we'll talk more about that at the session on Friday. I just wanted today to really make sure that we covered a little bit of the history, the significance, the challenges we face, plus what the challenges are, the changes are, I should say, before we start getting into the mechanics. So how do we make this work? If we go back to the minimum rates, I think that's important. Where we see the challenge for employers is meeting the minimum rates for the graduates, and also potentially level 2 experienced professionals. We would expect that your level 3 professional, which would usually be someone with, 5 to 10 plus years experience, that pay rate will probably be reflected in your annual salary, and likewise for above. However, not in all cases. We know that from our survey. It's important to remember these pay rates apply whether you work in a capital like Sydney or somewhere like Broken Hill. If your work is covered by this award, these pay rates, minimum pay rates, apply. And that's where I think also we may see some interest, potential areas to assist members as those working in regional areas in the private sector, potentially, where these pay rates are not reflected. Look, that's all that I wanted to run through today with you. I'll stop sharing and we'll start going to the questions that have come up. So, Remy, do you want to run through those now, or start running through those?
Yeah, thanks, Margaret. There's been a few questions about if an employer is paying the 25%, are they still required to keep records of the overtime worked? And if they are failing to keep records, how does someone go about trying to enforce that?
Yeah. That's really I think that's the interesting thing about the way the Commission has crafted this change. They've really said, if you don't want to have to keep records, you have to pay 25% above. But what we need to do as a union, I think, is look at, well, what does that mean, though, for those where it is 25% above? And is this award still providing an adequate safety net? One of the areas that we are still somewhat hamstrung with is the fact that the minimum rates of pay set out in awards are so much below what you might expect to be market rates. It's an ambition of the union movement that award rates reflect market rates, but I think it is an ambition. Nonetheless, one of the things that we could be looking at under this award, which hasn't happened for some time, is look at, well, given the hours of work, the nature of the work, the level of responsibility, do these classifications actually and pay rates reflect the work value of the work that's being done, which is a way of lifting the pay rates. But again, that's a collective effort. It's not something that we can just do via surveys. We got over the line on this one, but I'm not sure that if the employer organisations learn anything from the last case, they should know to challenge the evidence a lot bit more than they did. So the short answer is no. If they are paying more than 25%, they don't need to keep records. But what does that mean for us, and what we need to do, I guess, is a question I pose all of us to think about.
I've got another question from Peter, and he's asked, is the 25% inclusive of profit sharing bonus schemes?
No.
I found this on the web.
So profit sharing bonus schemes are not seen as part of your annual base pay, which is what the 25% plus would be, effectively part of your annual base pay. It's not subject to you meeting any particular requirements. It is your entitlement on an annual basis or weekly, monthly, however it's worked out. Depends on your contract. And the profit sharing is always seen as a discretionary thing. It's the same way as, so superannuation will be paid on this 25%, whereas it may not be with an incentive payment, for example.
Eamon has asked, can an employer decide that toil has to be taken within a time frame less than 6 months?
It's the employee that has that. The employer has to agree. I think that's the critical question. And so I guess they could say, look, we're prepared to agree if you take it within 3 months. That would be their way around it, I think, of the full 6 months. The point of the 6 month period is to ensure that employees get it, that we don't lose records of what is meant to happen, and that if it goes back to this concept that if you're working these additional hours, these are hours that you've lost in some way. So you're either taking it as a payment to reflect that, or you're taking the time off. So short answer is that I can see a way that employers could say, well, we'll agree if you take it within X period. Otherwise, we're not inclined to agree. We'd rather pay it out.
Another question from Chiella. Is the 13 weeks averaging of the work hours the maximum?
Yes. So depending on, so most contracts don't refer to averaging of hours from what I've seen. They simply talk about 38 hours plus such additional hours. And sometimes they don't even mention 38 hours. They just talk about your hours of work will be between these times. But if you do have a contract that talks about averaging of hours, then it can't be for longer than the 13 weeks that it's done. Otherwise, that would be unenforceable for the employer to hide behind that, motive language, pardon me, for the employer to rely on that to say that, oh no, we haven't underpaid this person, we just are averaging it over this much longer period.
I think that's most of the substantive questions, and then there's just a few around the availability of this presentation and whether or not the recording will be made available.
I understand that it will be. What I'd like to do, though, and what I'd like to say to everyone here today is that I will follow this up with a couple of things, right? So there's session 2 that's coming up. In addition, we will follow up both of those sessions with a quick survey. And one of the things, though, that I'd like you to think about doing is inviting those who you know or think might be covered by the Professional Employees Award that may not be aware of what we're doing, either because they're a non-member or they're just, as far as you know, that they haven't caught up with this, to invite them to another session along these lines so that they can at least become aware of what the changes are, because I see a big task in front of us is educating and making sure that employees who come under this award firstly know that they come under it and know what these changes are. And then I, am hopeful that as a union, we can work together and really get the maximum benefit out of them. But that will really depend on, I guess, some of what we talk about on Friday. And I hope you're all able to come to that. Otherwise, I am planning to repeat both sessions, but the recorded session will be available for members to view. Thank you. If that's all for today, look, really appreciate everyone coming along. It's gone for about an hour. I was hoping we'd go for half an hour. So it just shows, doesn't it, that it's really hard to get through this. We'll take a note of all the questions. They will be vastly useful for us to prepare some follow-up material we'll prepare, which is around frequently asked questions, so that this information is available. And yeah, enjoy spring, new beginnings, new starts. Thank you.